Gibbo, G-I-B-B-O, that's the moniker, man's on a mission. Got a weird walk like a pigeon on commission through the council estate. He's moving with pace, got a crew of old geezers right on his case. Switching up outfits quick like a flick. 1 minute he's a Bobby, next to geezer with a stick. He's dodging and weaving through the market store mess. He's got a big grin and a cheeky little vest. It's Gibbo, mate, I'm on my Benny Hill now, chasing everybody through the whole damn town. With a ding ding sample, yeah, you know the drill. The whole manor's running from Gibbo Hill. He's on your tail, can't get away. He'll chase you till the end of the day. See him skanking through the high street with a purpose, yeah, tripping over curbs, but he just doesn't care. He's got a whole posse, a flash mob of fools breaking all the rules. He's a milkman, a butcher, a postie on a spree. He's a man of 100 faces, can't you see? 1 minute he's a flirting with the ladies in the park, next he's running from a vicar in the dark. It's Gibbo, mate, I'm on my Benny Hill now, chasing everybody through the whole damn town. With a ding ding sample, yeah, you know the drill. The whole manor's running from Gibbo Hill. He's on your tail, can't get away. He'll chase you till the end of the day. Now watch him pull a trick, a right proper stunt. He'll swap his suitcase for a rubber duck punt. He'll slip on a banana, then get up to salute. Still a traffic cone and wear it as a boot. He's hiding in a phone booth, but his bum's sticking out. He's got a water pistol making everyone shout. He's painting a fake door on a brick, will you see? Then he'll run right through it, faster than a flame. It's Gibbo, mate, I'm on my Benny Hill now, chasing everybody through the whole damn town. With a ding ding sample, yeah, you know the drill. The whole manor's running from Gibbo Hill. He's on your tail, can't get away. He'll chase you till the end of the day. Yeah, Gibbo Hill, the dawn of the chase.
Hello. Can you hear me?
Yes.
There we go. Okay, so we were just having a few technical difficulties. We think we've sorted them out. So, Cash, welcome. Now, Cash used to be accused of being me a very long time ago. Before I even knew any of you guys, it was that long ago. But Karen's here. Welcome, Karen. Sloofy. Welcome, Sloofy. Rescue all chats. Yeah, smash the like, share, subscribe. The reason I ask you to subscribe is so you can chat. It doesn't cost you anything or anything like that. Who else? Susie. Hello, Susan. Hello. Frank Meister. Now, Frank's probably going to be doing a live on this at some. Oh, okay. At some point. So here is his channel. I'll pin it because he's most likely going to be covering this at some point. So if you want his perspective on it, there you go. Aurora, good to see you. Apparently, allegedly. Oh, got some flags in there. 2 flags. I hope I'm not the frog. Anyway, so today we're going over. Christian are going to do it tomorrow. Well, there you go. So subscribe to Frank Meister, and tomorrow he's going to go over it with Kristen. Subscribe to Sloofy Sweetheart. Jinx has dropped her link. So the appellate team or whoever, somebody's put the document out there. Apparently it's not supposed to be out there, but we've got it. I've summarized both sides. We're going to go over both sides. I brought Leon because, well, she's a legal expert, because she's a lawyer. So she's going to help us navigate the laws and things like that and we're also going to stay neutral. So, regardless of your opinion, it doesn't matter because we're going to stay neutral and we're going to argue both sides. And we're going to take it in turns doing that. First of all, with the state brief. Okay, so there we go. Okay, so this is it. This is the states. So the main theme for the state is most issues they waived. Even if not waived, no error, no harm or harmless. Evidence against Allen is overwhelming. So that's their main theme throughout the document. Search warrant Frank issues. So they're saying there that the search warrant and the Frank's motion issues, the state of waived. No objection at trial. And then pre-trial motion, not enough to preserve appeal. What would you say to that, Lee? What would?
Yeah. So can you hear me? Okay.
Yep, loud and clear.
Okay. So to preserve a claim for appeal, like you can't just file a pretrial motion. So let's say you file a pretrial motion to suppress, the judge denies it, it goes to trial. You might think, well, I've already moved to suppress that. I shouldn't have to say anything else, but you do. You have to object at trial and you have to reassert all the same grounds that you raised in your motion to suppress. And what the state's arguing here is that they didn't do that. And not only that, the state is also saying that not only did the defense not object to certain pieces of evidence like the gun and descriptions of the gun and things like that, but that when asked if they had an objection, they actually said no objection. That's what the state has asserted in their brief. Now, I haven't read the transcripts. I don't know to what extent that's accurate or what it's not, but that is what the state is arguing, that they didn't properly object at trial, and that any pretrial motions that they filed complaining about the evidence are not sufficient to preserve the error for appeal. That is what the state is arguing.
Okay. So the next point that they've got is no intentional lies, omissions in the affidavit. I'm guessing that's the probable cause.
Yeah, so I was just sitting here like reading through the state's brief before I hopped on here, and so the state's talking about one of the witnesses, and again, I'm not a Delphi person, so I haven't read the transcripts. I didn't really follow the trial, but it looks like that one witness had described the person they saw as like muddy and bloody and wearing a blue jacket, and then it looks like the defense was arguing, no, they really said the person they saw was wearing a tan jacket. But it sounds like what the state's claiming in the appeal is that that person gave multiple statements, and that in other statements that person gave, they actually did describe a blue jacket and did say muddy and bloody. So the state's arguing that there's not even any falsehood anyway, because that witness gave multiple statements. That makes sense.
Yeah. Okay. So the next point is for the state is probable cause still exists regardless of the points that Lee's just gone over. So the defense, this isn't, by the way, I have got another one. This is just the defense responding. So misleading witness descriptions, bridge guy, car, clothing. Key omissions weaken probable cause. So that's what the defense is saying about it. The state's response to that is it's raised too late, and even corrected, still probable cause. So what do you mean by raised too late, Lee? Is that like, is there a time limit that they've got to bring this up? Like the two that I've just read out for the defense, is there like a time limit that they've got to bring these two things up, or is it a
Yeah,
case of?
I think what they're saying there. So in the state's brief, they describe what the defense's arguments were. So what I'm reading this to say is that the state that's how the state has summarized the defense's argument. And so when the state's saying it's raised too late, what I understand that to be meaning, and again from having looked at their brief, is they're raising some of these issues for the first time on appeal. Like you can't just let something go by at trial and not object to it and then raise it for the first time on appeal. That's what I understand that to be saying.
Oh,
sorry. Can I say something about the comments? Can I say something? Address the comment, just real quick. The defense actually has 15 days to file their reply brief after the state files their appellee's brief. They get 15 days, not 21. And so just to be clear, like they can get an extension on that, but under the appellate rules, it's 15 days to file your reply brief as opposed to 21. So I just wanted to clear that up.
Okay. Yeah. So going into more like a topic basically, and the topic is confessions. It says confessions and voluntariness, and this is from the state. So they waive the issue. No police coercion required legally. What would you say that means?
So again, they're saying that this issue is waived because of the way the defense handled it at trial. What they're saying is that the defense didn't raise appropriate, so they didn't raise contemporaneous objections, meaning when the state offers something into evidence at trial, that's the point you have to object. You can't wait. You can't hang out and just sit on your hands and let it come in and then say something about it later. You have to make a contemporaneous objection. You have to object at the time that the evidence is being offered. And so what I'm looking at the state's brief right now, and what the state is arguing is that there were lots of pretrial objections to the confessions coming in. But then when it came actually to the time of trial, the defense didn't properly object at the moment the witnesses were talking about it, or that the objections that they raised at trial are different from what they're now arguing on appeal. So there's kind of the state's arguing there's two problems with the way it was preserved. It was either the objections were either untimely or not made, or the defense is now raising different grounds on appeal than they argued in the trial court.
Okay, so the next point, I think what I meant was like where it says required legally, and then I was on about police coercion. Is that saying like basically?
I'm sorry, I misunderstood what you said. What you asked. I apologize.
Thanks more anyway in detail, but yeah. So that's basically saying like police didn't go to him to get him to confess. He did it willy-nilly.
Yeah. So what they're saying. So when I read the brief, what I read it to be saying is, look, even if we accept the fact that he was profoundly mentally ill and suffering from all these, mental health issues, which it's my understanding there's some evidence of that. That doesn't mean that the confessions get suppressed. There has to be police coercion. Like we don't suppress these confessions just because he's suffering from a mental health issue. There has to be police coercion. And so that's what the state's arguing, is that there's no evidence, there's insufficient evidence or no evidence of coercion. So like the police, they're saying law enforcement or the state didn't do anything to him to get him to confess, even if we accept the fact that he was making these confessions as a result of mental illness, is what I think I think that's what the state's arguing.
Okay, so this next one, prison conditions and standard, not extreme. So I don't know what you know about his prison conditions, but so the defence argues, you know, he was in solitary confinement, locked away from everybody, and that was unjust. But the state argue, well, he wasn't in solitary confinement, and we've got listed below. You know, he had, you know, medical care, communication. He had basically um, people that were in prison would talk to him. Guards would be at his door talking to him, things like that. Mainly to keep an eye on him, but also to talk to him. And then he also had access to recreation. He had an hour a day where he was laid out the cell and things like that. What would you say about that? Like, would you say that that's standard for someone in his position on murder, high profile? On a murder trial, high profile. Think you know what I mean.
So, so safekeeper status is pretty rare. It's not very common. Like where you regularly or most commonly will see safekeeper utilized in Indiana is with the killing of a law enforcement officer. Because if someone's accused of law enforcement officers, then they're held in the county jail, ostensibly where they are alleged to have killed a law enforcement officer. There's an argument to be made that they wouldn't be safe there. So you typically see it most commonly with, the murder of a law enforcement officer. I am familiar with the facility at Westville. It's pretty rough. Like I've heard people want to like kind of debate the fine points about whether this is solitary confinement or not. I say that it is. Solitary confinement doesn't mean you never see another human being. Like as a matter of practice, the amount of time he was spending in a cell alone, I think would qualify under a legal definition of solitary confinement.
Okay, so
yeah, go ahead.
So he also had access to a tablet. I'm guessing he had pictures of his loved ones, things like that. So again, for me, that means it's not solitary because he has, he can call his wife. He can. I don't know, like what he was allowed to do on the tablet, but he had it there. I don't know whether it's for reading. Maybe he had reading purposes on there. Certain things he could watch. Maybe I'm not 100% sure. But wouldn't that be like a main reason why it's not solitary confinement because he had access to things like that?
Yeah, I mean, someone could make that argument, but I think it's interesting because I don't think the state's making that argument. I read the state's brief to not be like disputing whether or not this was solitary confinement. What I read the state to be arguing is that let's assume it's solitary confinement. That doesn't make his confession involuntary. And I'm looking at like pages 50 and 51 of the state's brief, like they because I don't think they have to take that on to succeed on their claim, right? They're just like, look, let's assume it was solitary confinement. Even if it was solitary confinement, that still doesn't make these statements involuntary. And they have some, what looks to me anyway, to be some reasonably persuasive case law on that point. Now, I haven't read any of these cases. I'm just reading the state's brief, and that's their perspective on things. But, that's if all the cases that they've cited stand for what they say they stand for, then that's a good way for the state to have argued that, to say, look, let's assume for the sake of argument it was solitary. Doesn't matter, because there's all these cases that say even being in solitary confinement doesn't necessarily or inherently render your statements involuntary. Does that make sense?
Yeah, I'm completely with you. So Jinx says, it's great having Leon. Thanks, Gibbo. And then Rescue says, it was all my idea. You're welcome. But it was Rescue's idea. I myself wouldn't have had Leon,
Yeah, I had to bully my way in here.
Rescue brought it up, and then Lee was in my kept coming into me in voices, and so Susie says Lee's great. So we'll leave that there for a second and go back to.
Yeah.
Okay, so the defence is saying confessions result of isolation, mental decline, conditions were coercive. So would you say that being in isolation, someone's going to come out and confess? Have you seen that before, or?
I mean, I've had clients who were severely mentally ill who made incriminating statements while they were incarcerated. But I would also say this. So you have to look at like the whole picture. And so the question is here, like, because the state's right, they have to show that the state coerced him. And the defense's argument, I'm not super familiar with everything, but the defense's argument is, they put him in those conditions. They knew he was suffering from mental illness by their own policies, their own internal policies in the Department of Correction. Those exacerbated his mental health issues, and so that's the coercion, right? Keeping him in there against their own policies, beyond the point where experts would say you can safely hold someone with mental illness. I think that's what the defense's position is. That the
I'm not sure how many days,
yeah.
but I have heard about that when the case was going on. Now I'm not 100% sure if you've just answered this question, so I'll ask it and then you can say whether you answered it or not. But can't the defence show that solitary confinement can cause mental harm that affected his defence? And that's from Mark Shield.
So again, Mark, I'm not trying to be like evasive on this. I don't know the answer to that because again, I'm not like super familiar with how the evidence came out at trial, and I don't want to say something that I can't back up or point to as being accurate or not. But in theory, so take a hypothetical case and not this particular case. Like you could, in theory, show that exact thing. Like if you have someone who comes into, again, assuming we're going to call it solitary confinement for the sake of argument, you have someone who's not suffering from severe mental illness before they come in, and they're placed in solitary confinement, and they start to develop mental illness or a mild mental illness that they may have been struggling with before becomes more serious. Like I think that you can show a correlation, maybe not causality, but you can show a correlation between the solitary confinement, the conditions of confinement, and the increase in symptoms of the mental illness. But I can't say whether they did that here or not because again, I haven't read the record, and I don't want to.
Well,
I don't want to say something I can't back up.
Jump back into it. I just want to point out that I can agree with what you're saying there, but I mean, it was literally days after his arrest, and I mean literally a few days after his arrest, that his first confession come. He called his wife and he was telling her, "I need to tell you that I did it."
It was that quickly?
Yeah. See, that's one thing that always gets argued, but you can't argue with documents. The documents are out there, but for whatever reason, they tend to get ignored, things like that. But yeah, the first confession was days after his arrest.
I did not know that.
Yeah, because he was arrested in the October, right at the end, and it was days later the first phone call come through. Mark says thank you.
You're welcome, Mark.
So isolation can cause what you're saying. Conditions. I think you basically covered that in the isolation, really, didn't you? But so his conditions was a cell. He went out the cell, I believe, every day in the week, anyway, to see Dr. Waller, where she talked to him, got him on medication, got him to cough medication, things like that. So he was definitely looked after mental health-wise. But another thing that Dr. Waller pointed out, which I don't think is really important, because the state's probably going to say, it doesn't matter. But so they pointed out that he was feigning, he was faking the mental illness. He'd come in, I mean, he'd be what's it called? Either I can't remember which way it went, whether he was acting up and then she turned up and he'd sit down and act normal, or if it was she'd turn up and then he'd start acting up. Do you know what I mean?
Yeah. So they were saying that he was malingering, that he was faking. Is that what she was saying? Okay.
Her argument that
I mean, I know people who are held in much harsher circumstances than Mr. Allen was, who do not confess and do not experience like these types of the types of mental health issues that I've seen described in the briefs that I've read. But there are some people who are in less harsh conditions who struggle worse. So, I mean, people do have to be viewed on an individual basis. But that's the job of the person's lawyer, is to present evidence of their particular unique circumstance and to call expert witnesses about how their circumstances or the conditions that they were experiencing impacted them in their particular situation. I mean, it really does have to be an individual assessment. Because like I said, I know people who are held in much harsher circumstances, much more isolating, who don't have the same experiences. So it really does have to be viewed on a case-by-case basis.
So the state's arguing to that mental health does not equal coercion. So my guess would be they're saying just because he was mentally unwell doesn't mean he was confessing because of that.
Correct.
And then there's no state misconduct shown. So basically they're saying there that, we weren't involved. We stayed back, let everything happen, let the defense deal with everything and things like that.
Yeah, I mean, so they're disputing that the state, meaning the Department of Correction, I mean, it's all the state, right? So they're disputing that the state created the mental health problems in the first instance. And then they're saying because the state didn't cause the mental health problems or the mental health issues, we can't, the state's saying you can't call this coercion. Like they didn't create a coercive environment is what I read their argument to be.
Okay. So the next one is, it sounds really exciting. Fruit of the poisonous tree. Sounds really exciting. It is literally just waived underdeveloped argument. So what would that mean? Would that mean like they haven't made any points? They haven't added any detail? What would an undeveloped argument be?
So that would just mean, so that could mean a couple things. I'm trying to find the argument here. I thought I had it open in my thing so I could search. So if the state's arguing that the argument is waived, again, it's going to be because of a lack of a proper or timely objection, or if they're saying that the argument is underdeveloped, what they're saying is that that on appeal, at least this is what I understand them to be saying, what they're saying is on appeal that they didn't cite appropriate cases or make a sufficient argument citing cases and then analogizing them or comparing them to what happened in Mr. Allen's case.
Okay. Confessions too far removed from search.
Oh, yeah. So I read the defense's argument to be that, okay, so tell me if if you can follow my logic here, because this is what I think the argument is. So they're saying that the law enforcement should have never been able to search his house because of what they say were false statements in the probable cause affidavit. If they hadn't searched his house illegally, they wouldn't have found the evidence that they were able to then use to arrest him. And if he hadn't been arrested, he wouldn't have made the confessions because he wouldn't have been in custody. So,
Okay.
so the state's argument is there's too much happened between the time that the defense is saying there was an illegal search and the time that the confession started. Too much time passed. So you can't link the two things.
So it says here, intervening factors break any link.
Mm-hmm.
Do you know what that's about?
So you have to, if you're arguing that, if the argument is that that the confessions resulted from the illegal search, then you have to anything that happens in between can like break the link of causation. So
okay. So basically, let me dumb this down because I'm dumb. So basically, what you're saying is confessions stem from illegal search. So what the state is saying is the confessions don't stem from the search of his house. Is that what they're basically saying? So there's no link.
Yeah, too much time passed and too many things happened in between the two things.
Okay. So yeah, we've just gone over this, but confessions stem from illegal search. That's what the defence are saying, and then the state's response is no causal connection.
Yeah.
Evidentiary issues. So the defence here are saying that there's evidence issues, and they say bridge guy sketch, and the state say not admitted, irrelevant. Defence doesn't match Allen, and then it says expert Tobin, and then state not qualified, not relevant. Does that mean that Tobin was not qualified as an expert?
Yeah, so those are two separate things. With the bridge guy sketch, the defense is saying they should have been allowed to admit that into evidence to show that it didn't match Richard Allen, and that means it could have been that really the person that was seen. Is it Ms. Blair? Is that the sketch? Is that who the sketch came from? Was Betsy Blair? Okay.
Yeah.
So what the state's saying, look, that's waived. There was a motion in limine on that, and then the defense didn't tender it at trial. And so if they wanted to preserve that for appeal, they needed to try to get that admitted at trial, and they didn't offer it. That's what the state's arguing on appeal. It's waived because the defense didn't offer it into evidence at trial.
Basically, the state didn't admit it. They didn't want to use it, which a lot of legal experts and people that go through the court system have all said, when have you ever seen a sketch used in court? But what you're saying is, so the state's saying we didn't admit it, so it's irrelevant. And what you're saying is the defence should have attempted or succeeded in getting it admitted during the trial in order to be able to use it in the appeal.
Yeah, if the defense wanted to complain about it being kept out of trial, they needed to try to admit it as evidence at the trial. And what I read the state's brief to be saying is they didn't do that.
But what's this about not qualified, not relevant? Is that going back to what we've just been talking about? Is that so it doesn't qualify because
no? That's the second argument. That's about Tobin's testimony. So Tobin is, I think, the guy they wanted to call. The defense wanted to call him. He was a metallurgist or was going to testify about some tool mark evidence. And I think his testimony was being offered to counter Melissa Oberg, I think.
Yes.
Am I remembering this person right?
What you're saying is, So this is regarding the bullet. So he wasn't a firearms expert or, you know, a ballistics expert. He was just a metal. So he's not qualified. So he's not relevant. And the defence challenges the bullet science and reliability. Okay, this is where we get to ask this question. Do you know anything about the what happened? Because I can give you a quick what they did with the bullet.
I know yeah, I know the basics. I do.
So you know that they fired the bullet to compare it. Now, what's your argument on that? Would you waver towards it, like being admitted? Like if you was defending someone, would you want to use that to defend it? Like say, look, it doesn't match his gun. We fired the bullet, things like that. Or would you say we need to just ignore that? It's not relevant.
I mean, I would have tried to get about out there about how yeah, can you hear me?
I can now.
Can you hear me?
You broke up for a second. Are you there?
Liability of tool mark evidence generally.
Okay, Lee, you're breaking up.
And
Lee, you're breaking up. Look, I can't. Can you just quickly jump out and jump back in? Hello.
I'm trying. I'm sorry.
You're okay. You're okay. Right. Well, go over the bullet. So what happened was, for those that don't know, they found a bullet at the scene. It wasn't fired, but it had markings on because it had passed through. Me Monday can't use Odin in court case, but we still call it F3. I don't know anybody who said F3 today. Okay, Lee is back. Sorry about that, Lee. I don't know what was going. I couldn't hear you, and then I could, and then. Are you there?
Can you hear me now?
Yep, now I can hear you loud and clear. So, I asked you, like, would you want to use it? Do you think it's junk science and would avoid it?
I mean, I would have tried to call this expert to counter the state's evidence. Tool mark evidence, there's all sorts of data out there about it being unreliable. So I probably would have tried to call this expert. Well, I don't know if I would have tried to call this particular expert. I don't know enough about him. I don't know how good he was or if he was the right expert. But I would have wanted to put on expert testimony to counter the state's evidence. Yes. I mean, there are problems with tool mark evidence. There are lots of reports and data out there, and yeah.
So you'd want to counter it, but you're not sure on this expert, like whether he was qualified or not, or if you had.
Yeah, I don't know enough about him. I don't know enough about him to say if I think he would be right in this particular circumstance. I just don't know. I'm sorry.
In my opinion, it stands because, they are arguing it now, as in what's it called? Defense teams are arguing that it's not a science now, but nobody's proven that it's not an exact science. That's why, like, when they say, and you can correct me if I'm wrong here, because you know, but that's why they say, oh, well, you know, but they can't, you know, you can't, like, you've got to, like, there's no case where it's been overturned because a defense team has actually not just challenged it but beat it. Do you know what I'm saying?
Yeah, So yes, but I'm going to push back on that. And what I'm going to say is the party proffering the evidence has the responsibility to prove its reliability. And so the state was the one who, in the first instance, had to establish the reliability of the testimony. Again, whether they did that or not, I don't know. But it's the state that has the first obligation to do that. Maybe they did, maybe they didn't. I don't know. But we don't assume that scientific evidence is automatically reliable. The party who wants the evidence in has to establish its reliability.
So, Me Monday, we're now into a topic that you mentioned and will probably like listening to. So, third-party Odinism, the state, speculation only, no direct link, suspects had alibis, defense, alternate suspect theory. So, Indiana state law, quote me if I'm wrong, correct me if I'm wrongly, is in order for it to be admitted into trial, it has to be, there has to be some form of substance to it. So, for example, it can't just be hearsay.
Well, so it could, in theory, just be hearsay. It would depend. I mean, hearsay is not admissible unless it's falls under an exception. There are lots of exceptions under which hearsay evidence can be admitted. One example of that is if the person making the statement is making a statement against their own interests. So you can imagine that confessing potentially to a crime is making a statement against your own interests. So that could, in theory, be admissible, even though it is hearsay. The fact that it's hearsay doesn't mean it automatically doesn't come in. It means it probably doesn't come in unless you can show it falls under an exception.
Okay, so I looked this up and it states, I haven't got it up, but I can if you want. But anyway, when I looked it up, it said that basically there has to be some substance to it. There has to be a nexus. You have to either link them to the scene, the crime scene, or what you're allegedly arguing has to be more than hearsay. That was Indiana state law that I got up.
Well, I would love to know what case that is that says that.
Let me get it up. Da-da-da-da. Third party. Is that right? Third party. Let's have a look.
Mm-hmm.
Okay. Alternate suspect. Let's write it how they wrote it. Alternative suspect. Indiana law. Third party culprit evidence allows a defendant to argue that someone else committed the crime and raise reasonable doubt about their own guilt. To be admissible, this evidence must have significant connection to the crime and cannot be purely speculative. So, this, I don't know what you know, because you never really followed the case, but so the defense said that Odnis did it, but they specifically named people, but like their, if you will, evidence was things like an ex-missus of one of them who stated that they were blind drunk at the time it happened. So if he doesn't remember saying it, how does she remember it happening? Would be an argument, I would argue. But anyway, so another guy was Elvis Fields, and his sister said he confessed to her, but his sister was a drunk. Sister was, well, in fact, the officer that argued argued that the sister should be used. Murphy, in his own statement, said, what's it called? No, oh, I see. So the officer that argued that should be used, Murphy, also said in his statements that when he went to the house, she stunk of alcohol. Like whenever he spoke to her, she stunk of alcohol. When he went to the house, there was pill bottles, like whatever, I don't know what you call them, but there was them everywhere, and she didn't seem right. And then he basically even said at one point she was full of shit.
Yeah. So
Yeah.
I would love to know the name of the case that you found that you were talking about, this nexus connection, because I do know the law, there did come a point when the law changed on that area once Indiana adopted the Indiana rules of evidence. So I don't know if the case that you were looking at was a pre-rule of evidence case, but I mean, the rules of evidence govern the admissibility of evidence. Evidence is admissible if it's relevant, if its probative value outweighs any prejudicial effect. And so, I mean, there are.
Would this help you?
Sort of,
I've got. I don't know if this would help you. Alternative. That's misdemeanor. I don't know what that's about. Alternate suspect and evidence criminal law. Criminal law notebook. Oh, that's a website I'm not navigating. So that's from criminal law notebook, and then underneath it says significant evidence needed. Evidence suggests another person committed the crime must show significant connection between that person and the crime in question, rather than just suggesting a general motive or propensity.
Yeah, no, I would agree with that. Like, you can't just like make vague accusations or claims and then expect. I totally agree with that. I don't know that I think that the nexus between the third party and the criminal act has to be as high as maybe you're suggesting, but I would agree with you though that you can't just like make shit up and like say I should be allowed to present that to the jury.
Where they got the confessions on these two, it was Brad Holder and it was Elvis Fields. Elvis Fields was apparently at a hospital appointment or something like that. He had carers with him or something like that. I can't remember Elvis Fields, but Brad Holder was at work. So his ex-missus saying that, he was he was with, I think it was Patrick Westphal, and Patrick decided he's gonna this and this. But Patrick Westphal was at home. We know that from cellular data. He was in and around his home. Elvis Fields, I can't remember what Elvis. I'm sure it was something to do with a hospital appointment or visiting a friend at hospital. But Brad Holder punched himself into work. He went to the gym. All this, there was proof of it. Do you know what I mean?
Oh yeah, and I want to be clear. I don't know enough about it to say or to have an opinion about whether it should have come in or not. Here's what I would. Yeah.
What I'm saying is
Go ahead.
Go on. No, go on.
I was going to say, what I would say as a general matter is that if it's a close call, in my opinion, and I'm a defense person, so I'm a defense lawyer, so I have my opinions about such things, but I feel like if it is a close call, a judge should err on the side of letting it in. Why? Because you don't want an appellate court reviewing it later and being like, that was a close call. We're going to send it back for a new trial. You just don't want to create a circumstance where that's going to happen. So if it's close, you should let it in. I don't know if these were close here. I don't know. I believe what you're telling me. I have no reason to doubt what you're telling me about about what happened, or what the circumstances of these other people were. So, in those circumstances, maybe it was appropriate to keep it out. But as a practical matter, if it's close, it should come in.
Yeah, but what I'm saying is it was so ridiculous. Okay, so so for example, in the confession from sister, she said that Elvis gave her a blue jacket covered in blood, and she was willing to hand it over. That never happened. It never happened. Murphy went out there, and it never happened. He could never get the so-called jacket that she claimed to have. He asked Officer Murphy, what if he spit on one of the girls? His DNA wasn't found on either of the girls. And he also, to that, he said, it wasn't a question. It was more like a rhetorical thing. Like he was asking, as if like he was genuinely interested. Do you know what I mean? It was like, do you know what I mean?
Oh, yeah. Like no, I get it. Yeah.
Yeah. He was constantly trying to make conversation, and because he was lonely, his own family didn't want it. Oh, yeah. I attended pre-trial hearings and listened to all of Officer Murphy's testimony and took notes. And did you draw pictures of penises? I bet she did. I bet she did. But yeah, so like
I bet she did.
But like what I'm saying is, I'm all for alternative theory, just because as a bystander, it makes things more interesting. But like, it was so bizarre. What it's like as well, like with the defence, they argued that when the what's it called, the state rebutted, or whatever you call it, when the state basically, like the defence presented the Odinites, and then the state then showed evidence why the Odinites didn't work. And then the defence's argument, instead of moving on or whatever, they argued and argued and argued. Well, we haven't got this evidence. And then they then behind the scenes be arguing, we need this evidence. So the state would point to the evidence to them, and then they would argue then that, well, we had to nag the state for this evidence, so it should be omitted. But the states then responded and said, we didn't give them the evidence. We pointed to where it was in their discovery. Do you know what I'm saying now?
I see. Yeah. Yep.
So, like, it's a bit all over the place. Let's move on from there anyway. So the suspects had alibis. Where are we? Third party odinism. We've got the state, the defence, alternative suspect theory. So should we just allow that? Is the defence's argument that, well, the appellate defence, is that argument that alternate suspect theory is whatever whatever a defence puts on, if they bring out an alternative theory, that it should just be allowed?
Yeah, no, that is not what the law says, and I would not want to be understood to be arguing that. I just if I guess all I was trying to say earlier was, like, if you have some evidence of a third party, but maybe it's not super strong, maybe it's a close call, I think a judge, for the sake of like making sure that a defendant's due process rights are protected, should err on the side, like if it is an error on the side of letting it in if it's a close call. I mean, what I hear you saying is you don't think it was a close call here, and I defer to you on that, because I don't know enough about it to really have a good opinion. And I like it when you boss me around, so there we are.
Well, I do like to boss people around. So this just has the state, but it's harmless errors. Even if mistakes happened, doesn't matter.
Yeah.
Evidence.
Yeah.
So evidence still strong enough to convict. So Go on with what you was going to say.
Oh, so what the appellate courts love to say, appellate judges love to say, is that no.
Hold on a second, you're breaking up.
Is that any better?
Hello?
Hello?
That's better, yeah. Yeah, that's
Okay.
better.
So what I was saying was that appellate judges love to say that you're not entitled to a perfect trial, you are entitled to a fair trial. And so what that means is just because like mistakes happen or a judge makes a wrong ruling or something happens doesn't mean you are entitled to relief. It doesn't mean you get a new trial. So sometimes there are errors that happen, and we acknowledge them and we accept that they happened, but they're harmless. In other words, it wouldn't have made a difference to the outcome of the trial. And so what the state's saying is, look, even if there were errors here, even if there were mistakes made here, it wouldn't have mattered because the evidence, they believe the state's evidence was strong enough that even with any mistakes that were made, there still would have been a conviction. That's what they're arguing.
Yeah. Back over that. So I've lost where we was because of future the Poison Street, evidence, bridge guy.
Scroll down some
harmless
more.
error. We've been over that. Some more.
Well, what I'm seeing
anyway.
on this.
So
okay.
We're here. Alan admits to being on. So key evidence. This is the state's focus. Alan admits to being on a trail. Witnesses match that with their timeline. Parked at CPS building. Video evidence supports timeline. Cartridge linked to his gun. Multiple confessions. And the closing point. Oh, do you want to go over that or?
No. No.
Okay, so the closing point for the state is claims waived or weak, evidence strong, convictions should be affirmed, and then we've already done this. We made our own talking point, and I've just stopped myself. So that's that for the state. Do you want to go over the defense, or do you want to get off?
I could be done, but I don't have to be. If you want to talk some more. Okay.
Well, I don't want you to be doing something that you don't want to do. Do you know what I mean? I don't want you to look. I'm holding you against your will. So the defense is actually shorter as well. So if we can fly through this because we've literally just gone over the same thing. So the main thing for the defense was trial was unfair, key evidence wrongly admitted. Okay, defense was restricted, conviction should be reversed or new trial. So is there anything that you've been able to point out that the conviction should be reversed or new trial?
Well, I read Mr. Allen's brief when it was filed, and I thought it was good. And I have, again, not having read the record, I was relying on what was argued in the brief, and the state raises some really strong issues with the defense's claims in terms of waiver. I mean, that's the state's favorite thing to argue on appeal, that an issue was waived and shouldn't be reviewed on the merits. And if what the state is arguing is accurate, then it does sound.
Okay, so what you're saying basically is the defense's appellate defense's brief was good in your opinion, but the state's arguments were also strong.
Yeah, and so I hesitate to say much more than that, because what I would normally do, like if I was working on this case, I would take the state's brief and I would look up all of the case side. I would go to all of the places in the transcript that they cite to, and I would read all of those. And unfortunately, I didn't have time to do that. So there may be things that the state says in their brief that are not accurate or exaggeration. I mean, that happens just like it happens on the other side. Defense lawyers can exaggerate. So, but yeah,
Did you
I have some concerns based on what the state argued.
What do you mean by concerns?
Oh, concerns about the strength of the arguments that were raised on Mr. Allen's behalf.
So on the defence's side, not the state side.
Yeah, and again, like, so the defense gets another opportunity. They get to file a final reply brief. And so we'll see when they file that, you know, how they respond to the concerns and issues that the state has raised. So we'll see. I mean, I'll want to read that as well when it's filed.
Yeah, someone was mentioning, we went over that earlier, didn't we? It's not 21 days, it's 2 weeks. So anyway, search warrant,
it's 15 days, yeah.
Do you know about the Frank's motion, like what was in it, kind of, and things like that?
I have a sort of general idea, not a ton of specifics, okay. But I know sort of generally what the claims were.
Yeah, it's basically the third party theory. This is the search warrant affidavit was misleading, conflicting witness. Oh God! So the search warrant, in my opinion, I don't, because it's basically the timeline. Do you know what I mean? So if the timeline convicted him, the timeline was solid. Why would it be misleading?
Yeah, I don't know. So to me, the bigger concern is. Sorry.
No, it's me. Sorry. Go on.
To me, the potential problematic issue is I think the judge should probably have just gone ahead and let them have a Frank's hearing. Appellate judges don't like it when trial judges don't let people have a hearing. Now, maybe there were reasons in particular here not to have that. But again, you just don't want to create problems. Just let them have the damn hearing. And let them, if their evidence is bullshit, then rule against them after they put it on. But denying someone the opportunity to present their evidence and make their arguments. And I know the state says they filed this big long thing and attached all these exhibits, but then what's the harm? Just let them have the hearing and then rule against him, and then there's no issue.
I mean, I can agree with that. If you're going to rule against it, then at least let them have the say. But I think they kind of did. Like, they had an alternative theory. But, like, see, there was a lot of, like, this is another thing that gets ignored from the Franks, is there was a footnote, and the footnote said, it was talking about Richard Allen was threatened by the guards, his family was threatened, like his family's life was threatened, and things like that. And then the footnote says, well, it never actually happened, and Richard Allen has not said it happened, but it could have.
Yeah.
Are you there? Okay, we've lost Lee, I think. Hello? Yep, we've lost her. Okay, so I'm going to leave it there. Oh, sorry.
I did something. I don't know what I did. Can you hear me?
Yeah, I can hear you now.
I'm sorry. I'm having so many technical difficulties. I'm sorry.
It's because you're using your phone, most probably. That's all. I know that some people, when they use the phone, they tend to get issues. It's just, I don't know why. Sometimes it happens, sometimes it doesn't. But my guess is it's because you're using your phone, because you should use using your phone. But so
Yeah.
we've got key admissions. So the defence's argument is the alternative suspect info. So basically that should have been added. Inconsistent timelines, but they come from the defence side, not the state side. So the state's timelines are the little girl's timeline, which has never changed, Betty Blair's timeline, which has never changed, but Richard Allen's did. And Richard Allen's was actually, if you watch the, I want to say confessions, but it's not that, interrogation, the first one, he goes along with the timeline, he agrees with the times and everything like that. But at the end, when they confront him, that's when we start getting different timelines. And well, he basically then outright says, well, you know, all this is wrong. Do you know what I mean? After agreeing throughout an hour's conversation that, yeah, that's right. Pointing at maps, yeah, that's what it was. Do you know what I mean?
Mm-hmm. Yes.
Yep. So what I'm saying is, would they be able to use inconsistent timelines when it was actually the defence side that had the issues with the timelines?
That's a really good question. I mean, if the defense had evidence, like based on how you've described it, I would say probably no. But if the defense had evidence to support their alternative timeline, other like independent evidence, and they admitted that and were able to show that, then I'd say they showed there was a problem with the timeline. If it's just based on Mr. Allen's word and they don't have any verifying evidence, I think that's probably a problem for the defense's argument on that point.
So the state's response to that is no intentional misrepresentation, probable cause still stands. Confessions, voluntary. The defence's argument is confessions were not voluntary, result of extreme isolation, mental health breakdown, Allen deteriorated, behaviour changed, statements inconsistent, conditions and psychological pressure. So, for example, when he was locked up, the famous point is he ate his own crap. But when you actually read whatever it is, reports or whatever, it goes to the fact that he didn't actually do it. It was like he'd get like he'd smear it on himself and things like that, but he wouldn't actually eat it. It would just be a case of but he wouldn't actually. He might have done it once and then realised and was like, nope, not again. Do you know what I mean?
I mean, once is bad enough, in my opinion. But yes, I get what you're saying. It wasn't a regular occurrence.
If he went, this is what I'm saying. Like basically, he went from either attempting to eat it or he did eat it this one time to, oh, I'm not doing that again, and was smearing it on himself. Then, do you know what I mean?
Yeah, no, I mean, we talked about it like somewhat before, but I mean, it's a problem because so suppressing the confession, suppressing the statements is an extreme remedy, and so to get that done, you have to show that the state, through some state actor, like procured the involuntary confession, that they were coerced. I mean, you have to show that piece of coercion. And someone, I mean, there are lots of mentally ill people out there who don't confess to shit. So someone being mentally ill does not, in and of itself, it's not enough to show coercion.
That depends
It's
on
just not.
The person with the issue, the mental health issue, which way they're swinging, I guess. Do you know what I mean? Like some people get angry, some people get depressed. So I guess it depends what the actual mental health issue is. I guess, and you know which way they're swinging with it. If that makes sense.
Yeah, no, I get what you're saying. I mean, and the severity. I know that major depression is considered a major mental health issue for purposes of like the restricted in solitary confinement. I know that's true. But there are degrees. Like if someone is schizophrenic and actively psychotic, that's just fundamentally different from someone suffering from depression in terms of like the impact on the voluntariness of their statements.
So violates due process. I'm guessing that's the points that we just highlighted. Confessions were not voluntary. Results of extreme isolation, mental health breakdown. Alan deteriorated. Behaviour changes. Statement inconsistent. Conditions psychological. Violates due process. Is that what that's saying?
Yes, that is what that is saying.
Okay. Well, the response to that is no from the state, and that's it. That's all I've got for that. No,
Right.
but that is it. That is from the defence's side. Maybe I can get Ruckus on one day, and me and him can have a good old argument as we do. But that is it, Lee. Thank you for what you've just done, because that was brilliant.
Oh, you're welcome.
Also, I would like to declare victory. I've just been a defence lawyer on my channel. I'm joking. There was no showing over things. I was giving her hypothetical situations, and she was giving us the law, legal reasoning for behind everything. But I will point out that I am taking this as a victory, even though we weren't battling. If you are a member, I want to point out to you that I've got some content for that. It's just me going out for a meal. They let me film, and that I didn't film myself eating, but yeah, that will be on members only when I put it together. We're gonna start looking at things to do on members only now that members are growing. We will do the members only lives, and I need some ideas for what you guys want on there. Lee, as always, thank you. You were brilliant. Maybe next time, come with a little bit of a better attitude, yeah?
Oh yeah, I'll try. I'm real sorry. Real sorry about that.
No, honestly, thank you. I took an hour and 13 minutes of your time. I now owe you an hour and 13 minutes. Thank you for coming up. And if you're a member, please use your Lee emoji. And I'm going to let you all go, especially Lee, who's just had to sit there and talk to me for over an hour. So please pray for Lee. Okay. Hang on, let me get this up. Great live, M. Thanks, y'all. And then there's loads of people thanking you, Lee, as well in the chat. I know you can see it, actually. But I just wanted to let you know. Okay, right, ending the live. Thank you guys for coming. See you all next time.